The defense did approach the state to consider the court entering a limited and narrowly defined gag order on the state, the defense, and witnesses, of course, including law enforcement in this case. Essentially what we have here is that the press has labeled this a high-profile case. We have filed, as the new lawyers, a second motion for change of venue, alleging the pretrial publicity is such that we cannot get a jury in this county. Respectfully, you denied that. As time has gone on, there has been commentary by the former prosecutor in this case. And the defense has taken the position that, look, we requested you to change a venue. We're not going to engage in out-of-court advocacy on issues, motions, etc., because we felt that would be somewhat hypocritical. Here we are asking for a change of venue, but yet we're outside the courtroom adding to the pretrial publicity. But what's happened is that these comments appear in print, they appear in the media, and we're not responding. And the concern that we have, of course, is for our client, Mr. Goodman, that not responding to the comments being made by some, that perhaps the general public is going to infer, well, the defense is not responding to this, therefore what is being said must be true, and it's to the prejudice or potential prejudice to our client. And again, perhaps we shouldn't ask for the gag order, because if it continues as it's been going on, then it just adds to our motion for a change of venue.
Seems to me it would be incumbent on the parties to come forward with evidence that Ms. Roberts has made such extrajudicial statements that are likely to prejudice Mr. Goodman's fair trial right. My review of those in the limited time I've had to look at them, I'm not convinced that that she has prejudiced his fair trial right. But if she is, wouldn't the right way to handle it be to give her notice and let her come into this court and then discuss what statements she's made, the context in which they've been made, the timing, let her defend those statements or deny that she made them, or as the case may be, and then make a decision that is narrowly tailored and does not do more than is necessary to protect the fair trial right. We've got these two mighty oaks. You know, we've got the First Amendment and we've got the fair trial right. And I would concede that the First Amendment right of access about this proceeding, although it's quite substantial and it's time-honored in our system, must yield when evidence is put forward that would allow the court to make findings that the fair trial right is truly endangered. But what the court doesn't do is take a chainsaw and hat rack the First Amendment oak. What it does is it takes out its fine pruning shears and it trims those branches only as necessary in order to make sure that the defendant's right is protected.
As a general premise, the path I'll take is it necessary? If so, what's the least restrictive means of accomplishing the protection of Mr. Goodman's fair trial right?